Assalamualaikum warahmatullahi wabarakatuh. This is the lecture for the topic vicarious liability. So I'm happy to announce that this is actually our final topic for the syllabus, okay, for Law 1511. So finally we have made it. We have come to the final topic. So let's see what we have for this lecture. So vicarious liability. So basically, whenever you see the word vicarious liability here, it refers to a situation where A is liable to C for damage or injury suffered by C due to the negligence or other tort committed by B. So in that particular scenario, there are three parties involved here. So A is made liable for the torts action committed by B towards C. So it's between B and C. B is made liable for whatever injury or damage suffered by C. So the third figure here is B, but then A is made liable together with B here. All right. So when we talk about vicarious liability in that situation, A need not to have done anything wrong. So it was not A who has committed the torts. Okay, he wasn't tortfeasor. And A need not even owe a duty of care to C whenever they involve negligence. Okay, so it's between B and C. B owes duty of care towards C, and A actually does not owe any duty of care towards C. But why? Why A is made liable in that particular situation? Because of the existence of special relationship between A and B. That's why A is made liable under vicarious liability. So that's basically the law. Okay, it revolves around that. The things that we are going to discuss for this topic. So the requirement of vicarious liability, there are actually two important requirements here. Okay, the first one, there must be relationship of employer and employee. Then only the issue of vicarious liability may arise. Okay, otherwise there's no such thing like liability imposed on one party for the torts committed by the other party. And then another requirement on top of relationship of employer-employee, the employee, okay, the tortfeasor, committed the tort during the course of employment. So that's another important requirement. So with until and unless these two requirements, these two elements are fulfilled, then only the vicarious liability could be established. Otherwise, B has to be made personally liable, personal liability rather than vicarious liability. Okay, before we go to discuss the further discussion on the requirements just now, so we want to know what's the rationale of having the law or the rule governing vicarious liability. There are quite a number of reasoning, okay, of justification of having such a rule of law. So one of them is that if the employer benefits from the employee, so surely he should also take responsibility when the worker commits a tort in the course of employment. So he has been benefiting from the service provided by his worker. So whatever fault done by the worker in the course of employment, so he has to be made responsible, legally liable as well. Okay, another reasoning of vicarious liability is that employer who was negligent in employing a careless servant, so he has to bear the cost. He has to be made responsible for the careless act of the employee, of the servant. And then another important rationale is that based on the deep pocket principle. Okay, usually employer in the better position to pay, okay, the compensation towards the victim, okay, towards the plaintiffs. So it will be fruitless, okay, useless at times to bring actions against employee, because why? They might not be financially able to pay the damages, especially if the amount of damages is so big, so huge. So if the plaintiff sue the employer, all right, so the employer actually will be more able to meet the payment, to in the position to pay, all right? And sometimes even employers have insurance coverage for their business. So whatever torts committed by the worker, so employer can, insurance coverage will pay. And employer is the one who paid the premium whatsoever. So that's basically the three rationale. Actually, if you read some paper on this, actually there are more, a longer rationale, but we just focus on the important one, the significant one. So at least there are three rationale of vicarious liability. Okay, now we go to the elements. Okay, just now we said we have two elements. Okay, the first one must establish the relationship. Okay, employer-employee, and then another one is the thought was committed in the course of employment. Okay, for the first element, uh, in order to establish that there exists relationship between employer-employee, so there must, I mean, it must be proved that actually there exists contract of service. Okay, between the employer and employee. So what's the test in order to determine whether there exists such a contract of service or not? So there are at least three tests here. Okay, we are going to discuss all one by one after this. The first test is control test. And then we have another test, integration test. Spelling error there. I'll make correction later. And then the third one is multiple test. But and for the second element, we're going to discuss it later. Okay, there are two tests. Okay, in order to see whether it's done in the course of employment. Okay, Salmon test and close connection test. So let's focus on the first element, which is employer and employee relationship. So in order to establish this relationship, okay, it has to be proved that the employee, the staff, the worker, the servant is under a contract of service and not a contract for service. So in this contract, there exists two types, okay, two different types of contract between employer and employee. Is either contract of service and contract for service. Contract of service, it means the worker, okay, the employee is an employee and is paid a salary. And because of that, because of the payment of salary here, this established employer and employee relationship. So that's basically the simple meaning of contract of service. And contract for service, it refers to okay, whenever the worker is not employed on a regular basis. But actually, the worker here is actually an independent contractor. So basically, even though they are using the term like employee, but legally speaking, from the legal perspective, from the tax law perspective, actually this particular employee worker is actually independent contractor. So whatever contract between employer and employee here, actually it is contract for service rather than contract of service. Okay, so how do we know whether this one is contract for service or contract of service? Because we must prove that there exists contract of service rather than contract for service. There we have three tests actually to be used. Okay, we have control test, the first one, and later we have integration test, and the latest one, the recent one is we have multiple tests. We are going to discuss one by one. Control test. Okay, what's the meaning of the word control test here? So this was among the earliest tests. Okay, the first test, the initial test, which was used to determine the relationship, okay, whether the worker is an employee or actually he is the independent contractor. And the landmark case is Short and G&W Henderson Limited, 1946. So from this case, the court actually formulated the rule or the principle here. It is stated, it was observed that it will be a contract of service if, okay, there are four requirements here. First, okay, if there is power of selection by the employer. So it all goes back to control. So employer has control to select, okay, the employee. And then the second one, there is power in determining salary. And the third one, there is power or right or of the employer to control. Okay, that's the importance here. To control the method and instruction in which the work is to be done. For example, controlling the tools, okay, whose tool, where to keep the tools, for example. And then the fourth one, power or right of the employer to terminate the services of the employee, to ask the employee to resign, to fire, basically the word we use. Okay, all right. I mean the layman term, fire. But then as the time goes by, okay, because initially the test was established in 1946, okay, but later, okay, it was found that actually the test is not so accurate. It's not really conclusive, okay, especially whenever employment involve, okay, the element of control which is so minimum, okay, whenever the employer cannot control and dictate, okay, their employee what to do, okay, although they are still employee. For example, doctors and engineers. Usually the superior, okay, whoever, the bosses, for example, employer or even Ministry of Health, cannot really tell doctor this is the way to treat the patient. There could be so many ways to treat the patient, so long the patient recovered. Okay, all right. Or even engineers. Okay, so this is basically the important point of the distinction between contract of service and contract for service. So contract of service, usually it is easier or straightforward cases. It's quite easy to identify because example would be clerks, okay, factory workers, those paid on a monthly basis. Usually those who receive regular salary, monthly salary, then it means this is a contract of service. But contract for service, the typical example would be because another term is they are actually independent contractor. So typical example is contractor doing renovation or grass cutter. Okay, and then what's the nature of their job here? Whenever there is a need for them, okay, they are called to do the job. After which they will be paid on completion. For example, to do the renovation work or even to cut the grass. So usually they are done by contractor. They are actually independent contractor, independent worker. Okay, they are not really monthly paid salary. Okay, they are not really monthly paid employer. We have another leading case here. Ready Mix Concrete Southeast Limited and Minister of Pension and Nation Insurance. So the company devised a scheme, okay, whereby concrete was to be delivered to its customers ready-made. So that's basically their business. L, one of the person involved here, L entered into a contract with the company to deliver such concrete on a daily basis, the ready-mix one. Okay, and then what's the arrangement? L was to deliver concrete, but as far as L was concerned, he was to run and to maintain and to repair and to insure and to drive his own lorry. So L actually owned his own lorry, and whatever arrangement between L and the company, okay, L is fully responsible to maintain, to repair, to insure, to drive, okay, his own lorry. And then how was the payment being made? He was paid on a mileage and bonus basis. So it depends on the mileage, okay, how many the distance of his travel in order to deliver the concrete. Okay, and then but still he was subject to all the rules and regulations of the company. So when the case was brought to the court, one of the important issues was that was L here an employee or was he an independent contractor? So the High Court held that, okay, actually he was an independent contractor and a contract of service should, because why? For a contract of service to exist, to be established, okay, it should have the following term. Okay, it must have exchange of skills for wages, whereas L was not paid based on wages. And then there must be agreement that he will be subject of control of his employer. So there's certain freedom actually enjoyed by L here. So he's not really the employee under contract of service. Yes, so that's the finding by High Court. So eventually L was not employee, but he was independent contractor under contract for service, not contract of service. We have another leading case, landmark case, common law, Cassidy and Minister of Health, 1951. So it involved 9 resident surgeons. What's the meaning of the resident here? They were doctors in training. Okay, they obtained their medical degree, but they are now, I think in Malaysia we have the term like housemanship, houseman whatsoever. Okay, so they are basically the resident surgeons, and they were negligent, okay, in their operation. So negligently operated on a plaintiff. That's why the plaintiff was suing this 9 resident surgeons. And hospital was held to be liable for the negligent operation. And actually, this resident surgeon is considered as employee under contract of service. Okay, so hospital as the employer was held liable under vicarious liability. But if we compare with another earlier case, Hillier and the governors of Saint Bartholomew's Hospital. In this case, the plaintiff was a consultant, selected consultant, and then in this case he was found, okay, he was observed as he was held to be independent contractor. So he's not really attached, he could be attached to the hospital, but he's not really full-time employee. Okay, he was paid maybe on whatever operation that he did. So he was found to be independent contractor, and he was merely using the facilities of the hospital. Okay, he was not really fully employed, okay, by the hospital. So we have the two similar profession here, but two different finding. The first one, contract of service, another one, the second one here, contract for service. Okay, let's go to the second test in order to see whether it's contract of service or contract for service. Okay, we have organization test, or we call it integration test here. Because few years after the control test, which is which was found to be not really accurate and it doesn't cover all situations. So this test was formulated, was developed, organization test here. So by applying this test, the court actually is trying, okay, to differentiate between contract of service and contract for service, so that they will know whether relationship of employer-employee exists. Okay. So in the contract for service, how do you apply organization task here? Person concerned can work as part of the organization, and his work, his service forms an integral part of the organization. So if this is fulfilled, then this is contract of service, then he is the employee. But whereas in contract for service, even though the work is done for the organization, but it's not integrated into it, but it's only accessory, secondary to it. Okay, it's not really integral part. Okay, it is still important part, but actually accessory to it, secondary, complementing to the organization. We have this case, a local case, Mak Yusof bin Daud and Syarikat Jaya Seberang Takir Seberang Berhad here. Plaintiff worked as a sawyer in the defendant's sawmill, and then during when he was working, he sustained some injuries. So now he is suing the defendant. So in an action for damages against the defendant denied liability, the employer denied liability, because he argued that plaintiff was not the the defendant was not the employer of the plaintiff. He said, no, I'm not your employer. And he said that plaintiff actually was the employee of another person by the name of Lim. Okay, and who actually plaintiff is defendant's contractor. So Lim, who was the defendant, who was the contractor. Lim is actually contractor of defendant, contractor of Syarikat Jaya Seberang Takis. So defendant was saying, well, actually, Mak Yusof is actually the employee of his contractor, okay, not really employee of Syarikat Jaya Seberang Takir. And then Lim, the contractor, was under a contractual arrangement to supply workforce to the defendant. So that's an argument by the defendant. So what's the finding by the court? This is decision by Saleh Abbas, federal court judge. He relied on the organization test, yeah, and it was held that defendant as employers, defendant actually was employer of the employee, because why? Plaintiff work was an integral part of the defendant's business, and in addition, important factors or reason here, the wages and number of lots to be sold was determinable by the defendant. So in a way, actually, some elements of control test was also in organization test. So whatever work done by Mak Yusof here is very important, integral part of the defendant's sawmill business. It's not really accessory to it. Later, okay, even organization test is not sufficient, okay, to really determine whether this is actually employer-employee relationship, okay, between the parties here. So the most recent and preferred test is the multiple test. Okay, what's the multiple test? Actually, this test will take into consideration so many things. Okay, overall effect of employment. Okay, for example, the court will consider wages, okay, under this test, wages, okay, whether there is control, supply of tool, where the tools are kept after work. It sounds like control test, okay? And whether there's any EPF which was being paid by the employer, and who has the power to approve the leave, annual leave, or also income tax deduction, for example. All those things. That's why it is considered as multiple tests. It's like combining control test, organization test, and also whatever factors which is relevant in order to see what's the overall effects of employment. Does it exist or not here between this employer and employee? So what is important from the three tests that we have discussed just now, okay, before the employer is found to be vicariously liable, so it must be, first be determined, okay, that the worker who committed the tort is the employee of the employer. Otherwise, the issue of vicarious liability does not arise. Okay, it must be established. It must be proved that there exists relationship of employer and employee. So therefore, if the employee is found to be under a contract of service, then he will be considered as an employee. And that employer will be vicariously liable with the employee. Okay, I think we stop here for the first part of our lecture. I'm going to continue in the second part of the lecture. So hopefully you have been able to understand. So let me stop share. Okay. So until then, Assalamualaikum warahmatullahi wabarakatuh.